Okay, let's just dive right into it. Welcome to this comprehensive explainer. Think of this as your ultimate survival guide for the RPK 2010 Legal Practice June 2026 examination. Whether you're feeling, totally prepared or maybe a little bit panicked right now, we're going to break down exactly what you need to know. We're drawing directly from your course materials and sticking strictly to that official exam scope. We've got a pretty heavy cognitive load ahead of us today, so we're structuring this explainer right along with your professor's exam blueprint. We'll be hitting 5 crucial pillars: exam scope on professional ethics, practitioner and client duties, marketing and advertising rules, navigating legal costs, and finally, practice management essentials. So we're going from the deep philosophical foundations of ethics all the way to the literal nuts and bolts of opening your own trust account. Let's not waste any time.
All right, Section 1, Exam Scope, Professional Ethics, focusing on balancing the law and the bottom line. Let's look at how the philosophical foundation of professional ethics actually dictates your daily actions as an attorney.
Take a look at this quote. It beautifully illustrates the dual function and, honestly, the inherent conflict of being a lawyer. You've got to assist your client and promote justice, but without losing your moral compass to mere profitability. It is dangerously easy in this profession to slip into a mindset where you start prioritizing what you can get away with over what is actually right. Your ethical framework is pretty much the only thing preventing that slide. And speaking of right and wrong, let's talk about the infamous Marie Biscuit bribe. Now, what's really fascinating here is the incredibly strict standard of the courts. A home affairs official was literally fired for taking a single packet of Marie Biscuits just to speed up a service. Yes, a packet of cookies. So for your exam, you have to remember this. The monetary value of a bribe, it doesn't matter. The courts judge the breach of trust, not the price tag. A bribe is a bribe, pure and simple. Okay, moving right along to Section 2, Practitioner and Client Duties. We're talking mandates, duties, and dilemmas. We are transitioning from personal ethics to your direct duties to your clients. Let's look at a classic dilemma. Your client, Joe Soap, looks you dead in the eye and confesses that he murdered his wife. So, what do you do? The absolute crucial point for your exam is knowing how to handle this exact nightmare scenario without violating your professional obligations. Do you run straight to the police? Do you drop the case? How do you balance your duty to the court with your duty to your client? Well, because of professional privilege, your lips are legally sealed. You cannot simply go to the police. Everything said to you confidentially to seek legal advice remains protected, even after a mandate ends. That privilege belongs entirely to the client, and only they can waive it. You can still represent him for sure, but your ethical duty as an officer of the court means you absolutely cannot put him on the witness stand to commit perjury.
But hey, before you even get to hear a dramatic confession, you have to formally take the case. And that means strict statutory housekeeping. You've got to verify FICA to combat money laundering, ensure POPI Act compliance to protect their data, check for conflicts of interest, make sure you actually have the competence to handle the matter, and give them a written fee estimate right up front. If you lack the skill for a highly specialized case, or if you just forget to secure FICA documents, you're breaching your professional duties before the case even gets off the ground. All right, Section 3, Marketing and Advertising Rules. Let's see how you go about growing your practice legally. We're shifting gears to the highly testable boundaries of how you can actually market a new firm. The Legal Practice Council and the Advertising Regulatory Board want you to succeed, sure, but they require all publicity to be in good taste and entirely factual. That means you must absolutely avoid these ego-driven marketing traps. You cannot compare your service quality to others. No used car salesman tactics here. You can't criticize other firms, you can't state your success rate, and you definitely cannot boast about some arbitrary best lawyers rating. Keep it factual, keep it dignified. This really hits the nail on the head for your exam. There is a strict line you cannot cross. You are explicitly forbidden from doing those aggressive, knock-and-drop physical pamphlets in mailboxes. But setting up a passive, modern presence on platforms like Facebook, that's perfectly allowed. It really boils down to the aggressive, unsolicited nature of a physical pamphlet versus a passive social media page. And just to add to that, keeping your firm listed in traditional, reputable directories like the Yellow Pages or Hoarders is an entirely permissible way to be discovered. It's factual, it's an established directory, and it completely aligns with the rules. Let's jump to Section 4, Navigating Legal Costs, covering tariffs, fees, and taxation. Now pay close attention here, because this is an area where the terminology can easily trick you on the exam. The fundamental exam difference you need to grasp is who actually pays for what.
Party and party costs are strictly the necessities covered by the losing party. Meanwhile, attorney and client costs include the broader, justifiable fees you actually charge your own client. Think of it like this. If you make an extra, comforting phone call to your client that wasn't strictly necessary to win the case, the losing party is not going to pay for that under party and party costs. But your client, they'll still have to pay for your time under the attorney and client scale. Now, if you want to use a contingency fee, what most people call a no-win, no-fee agreement, you have to memorize these strict statutory caps. And here's a massive red flag to remember. You can never use them in family or criminal law matters. Standard common law, let's just split the winnings deals are completely illegal. You must follow the Contingency Fees Act. You cap your bonus at a maximum of 100% more than your normal fee, and it can literally never eat up more than 25% of your client's total capital payout. So what happens when costs are disputed without a statutory tariff? You use this exact step-by-step taxation process to give the final bill the legal power of a court order. First, you draft the bill on the right tariff, get a date from the court, notify the opposition, and then the taxing master peruses it with both parties right there in the room. Meticulous file notes are going to be your absolute best friend here. Once the taxing master allocates the payable amount and stamps that allocator, boom, the amount becomes officially payable. Finally, Section 5, Practice Management Essentials. We're looking at formal requirements and daily operations. This is where the theory of law crashes into the reality of running a business. These are the absolute, non-negotiable formal requirements you have to satisfy before you can ever legally accept a client or a single cent of a deposit. You can't just hang up a sign and start giving advice. Under Section 86 of the LPA, you must open a trust bank account. You have to register with the FIC. You must notify the LPC with all your details. If you fail to do this, the LPC won't give you your Fidelity Fund certificate. And without that certificate, you are simply not practicing law. Once your doors are actually open, the real challenge kicks in: time management. To keep the practice afloat, you've got to master this time management matrix. The goal is to focus your energy on Quadrant 2, that's planning and strategic thinking, while ruthlessly cutting out Quadrant 4 time wasters like endlessly scrolling social media. If you spend your whole day trapped in Quadrant 3, dealing with other people's unimportant emergencies, you are going to burn out. I want to leave you with this thought. Aristotle said, "We are what we repeatedly do." Excellence, then, is not an act, but a habit. As you prep for this exam, ask yourself, which of these legal frameworks and daily habits are you going to repeatedly practice to achieve excellence? Because ethics, client care, fair billing, these aren't just things to memorize for a test. They're the habits that will literally define your entire reputation. So as you walk into that exam room this June, are you just trying to scrape by and pass the test, or are you ready to make excellence your daily habit?